Hello, today we have with us Maria de Lancastre Valente, People and Culture Director of SRS Legal and also partner of the same law firm, that will talk about the recent changes to the labor law. Maria, thank you for joining us.
Thank you very much for having me.
Can you tell us a bit about what changes are we talking about and the background of these changes?
The changes are the result of the approval of the so-called decent work agenda that was announced by the government to respond to a number of challenges faced by the labour market during the COVID pandemic. And this agenda addresses 70 measures, and it has basically the following aims. The first is to reduce employment instability, and so in this labour reform we will see changes related to economic dependence, so provision of services, temporary work and term contracts, outsourcing, digital platform workers, etc. The second is to boost social dialogue and collective bargaining. Also to promote equality in the labour market between men and women, and also to introduce or rather to boost joint responsibilities within the family. So measures related to boosting work-life balance. And then measures that reinforce the supervision of mechanisms and the cross-referencing of data among official bodies to reinforce certain supervisory powers.
Maria, for the purposes of this conversation, what are the topics that you would select as being the key topics for our audience?
So the first topic that I think is worth flagging out is the one that relates to economic dependence. And one of the questions that we're asked a lot about relates to employee qualification and risk of misclassification. And this is particularly sensitive for companies that are investing in Portugal or that have or whose activity relies on consultants or on service providers as well as on employees. The law already provides a definition of what employment contract means, and so that's not the novelty. The novelty here lies in the fact that the concept of economic dependence has been imported from social security legislation into the labour code. And so what this means is that whenever an individual service provider renders an activity for a company, a beneficiary, over a certain limit of income, that individual service provider will be deemed and understood as being economically dependent on the company. And that's an important aspect, because the qualification as an employee has a number of repercussions for companies. Obviously, it's more expensive. Obviously, service providers would then be brought into the framework of the labour code and treated as employees. And I think the other thing that is worthy of note here is, and that's introduced by this reform, is that the beneficiary of the activity, so the company that's benefiting from the services, will now have to apply a collective bargaining agreement to that individual service provider. However, we do not know in practice what that means and the impact that will have. If it means that these service providers are going to benefit from all of the provisions in the collective bargaining agreement, part of the provisions. So I think that's one of the issues that we're certainly looking at, and that's still a question mark, I think, for everybody, for us lawyers, certainly. And I think that that's something that companies should be paying attention to.
So, Maria, one of the hot topics of this reform is outsourcing. Can you tell us what these changes represent?
Yes, of course. So this measure was the object of heated controversy. What this means is that some believed and believe that it is not constitutional for the reason that it represents a restriction to the right to freedom of economic initiative. So basically what the law now says is that companies are not allowed to hire employees under outsourcing or to resort to external hires, to external provision of services within a window of 12 months following termination of employment. And again, this in practice, we don't know how this is going to operate, but at least in the short term, what it is saying is that companies are more restricted in their movements to select the way in which they want to manage their business and they want to manage their resources. So I think that's the key takeaway in relation to this outsourcing change.
And what about the application of collective bargaining agreements to service providers that is now in force?
Well, I think that's the other interesting, one of the other interesting changes, and it's a challenging change from my perspective. Because in particular in relation to this outsourcing regime that we've just been talking about, what the law is also saying is that service providers under outsourcing, so who are outsourced to companies, companies have a requirement to extend the application of collective bargaining agreements to them as well. So how much that is going to cost companies and the practical impact that will represent for companies is also significant. I think one of the tests will be the course of time, so to try and understand how companies are going to deal with this and how courts are going to deal with it and how the actual work inspectorate is going to deal with it and monitor this in practice.
Another matter that I believe it is of interest is the increase of the compensation. That, of course, means an increase of costs for companies.
Yeah, that's a very good point. So one of the key changes under this most recent reform is the increase of the compensation basis of payment to employees who were terminated unilaterally due to what we call objective just cause, so economic-based termination. So the former rule established 12 days base remuneration per each complete year of service, and that the number of days has now increased to 14, and this is for permanent employment contracts. And this increase has also taken effect in relation to term contracts. So the former 18 days base pay have now increased up to 24 days, and there no longer being a differentiation between fixed term contracts and term contracts for an unspecified duration, so or rather open-ended term contracts.
Maria, it was lovely to have you here.
Thank you very much.
Thank you very much for your insights. They were super valuable. And see you next time.